Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I am your host, Maryann Petri. You can find me and my books and blogs on dismantlingfamilycourtcorruption.com. The books are Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough. And the other book is Cry Out for Justice, Poems of Truth. And the other book is Raised by These Wolves, How Family and Federal Courts Are Failing Our Children, which is followed by Raised by These Wolves, Volume 2, Child Trafficking Through the Foster Care and Court Systems, which will be coming out July 19th. Feel free to buy me a coffee to help keep this podcast going. You can find that in the podcast notes. I have a brand new guest. I have Jay Shore on. He's a certified ADA advocate since 2017 and a DVSV survivor rights advocate. He's wearing this really cool shirt, and its initials are Invisible Disability Gavel Accountability Forum, which I think is really makes a statement. I totally welcome you, Jay Shore. How are you, and how did you get into all of this?
Happy to be here. Happy to connect with you, and thank you so much for what you do.
Thank you.
I got into this. Thank you for the question. I got into this because all of my life I realized that I had been reacting differently to things and not knowing why.
Mhm.
And in 2016-ish, I had a YouTube channel called Luck Fawyers Institute. And Luck Fawyers is a spoonerism, of course.
Mhm.
So I developed quite a following there, and I had some good people that would interact with me and give me pointers along the way, and I really appreciated that. What I was doing was making a chronology of my interactions with the police, with bureaucracy, giving tips on how to combat this. And in 2005, we lost our house to foreclosure, had 85% equity,
Mm.
and it was bank and court fraud, and I fought for a year and a half, and just due to attrition, I was exhausted. I had to give up, and
Mm.
it crushed me financially, mentally, spiritually, emotionally. And I went underground for about 3 years and drilled holes in the driver license, turned them in publicly on the county register, and got pulled over for that. Went to court, and they ended up not adjudicating my case for driving with no operator's license. I became uh, friends with the trooper, and pretty good acquaintances with the DA and the judge.
Mm.
And it was just a really life-changing time for me. I was going through what I consider hell,
Mm.
and uh, we just moved forward, but I never did quite fully recover from that major adult trauma of losing all of that. And it affected my home life, my family life. Um, and I just had to buckle down and do what I had to do as a dad to keep food on the table. And a lot of times it was, really creative. And when I got to Portland in 2016 and started this YouTube channel, had a friend of mine that reached out and told me about Dr. Karen Huffer. And she said, you should look at the term legal abuse syndrome. And legal abuse syndrome is something that I believe a lot of people have, and especially a lot of people that you interface with.
Oh, yes.
A- And it's a syndrome of where people use and or the courts use legal abuse against a litigant. And I believe that every court interaction is a disability under the Americans with Disabilities Act. A disability is a physical or mental impairment that substantially limits one or more major life activities. And when you go into court, there's communication that's affected substantially limited. There's interaction with others. There's thinking, concentrating, caring for yourself while you're in court. I mean, we're in extreme terror and reaction and dissociation. I believe court causes PTSD. I'm not a mental health advocate. I mean, I'm not a mental health professional. I am an advocate, but I uh, I can't diagnose anyone. But I believe that every court interaction for a pro se or unrepresented litigant causes some sort of PTSD and at least a disability, if not PTSD. So I
I
got it. I'm
oh,
sorry.
I agree. And do you think it also causes personality changes in both
Yes,
parents and children?
yes, it causes the affected individuals to withdraw, to dissociate,
Mhm.
to shut down, to not know how to react. Sometimes, I mean, if you go through the DSM-5 and look at the reactions of PTSD, it says that they're involuntary outbursts.
Mhm.
And this is a communication disability. Dr. Huffer promoted PTSD as a communication disability. And a communication disability means that you need all kinds of accommodations when it comes to court. To continue from when I was meeting Dr. Huffer, I called her and I had a rare connection with her because she knew what made me tick.
Mhm.
And so it was an immediate trust and rapport. And so we became dear friends. And she actually started feeding me people to help that she couldn't help. I didn't know she was as sick as she was when we were
Mhm.
talking. And she passed away in 2018. But in 2017, she had told me about a course that she offered, certified ADA advocacy. And she had worked a long time to get this course with John Jay College of Criminal Justice, which is an accredited institution because she had been doing it with King's College online and it was not accredited, so people would have to recertify. But John Jay is an accredited institution. So I went through this course, and about two-thirds of the way through, I was discouraged. And this is a PTSD response too. I was just like, this is not going to help. There's so much corruption. It's just not going to help.
Mhm.
And she encouraged me to finish, and I did. And she told me I'd be good at it. And I didn't know. I didn't know what she knew. And so I did finish, and I started doing this. And when COVID hit, that's really when I started kicking in full blast because people just needed help with so many different things as compared to what the mandates and requirements were and what they could not perform due to their disabilities.
Mhm.
So that's when I really got kicked into this full blast in 2020.
Wow. I was going to say, where were you in 2014?
Well, 2014. Hmm. No one's ever asked me a specific question. Like, I don't know exactly where we were in 2014.
I can tell you where I was.
Where were you?
Family court.
Oh boy.
Yeah.
Yeah, it's family court is it's American terrorism.
Hmm.
And it's I say, and I've said this before, that judicial immunity is social deviancy because judges can commit horrific, and many states have laws that say even if they harm you maliciously or erroneously, they're immune under judicial immunity. And this is something that none of the rest of us can do. And judges know they can do it. And therefore, they sit on the bench with this absolute power and commit horrific acts on the American populace.
Hmm.
And the Americans with Disabilities Act removes that immunity under 42 U.S. Code 12202 because it says that um, actions for ADA violations are remove state sovereign immunity from which judicial immunity flows. I want to make it clear that I'm not a lawyer. Anything and everything I say is absent intent or authority as legal advice today.
Hmm. Same here. I'm not a lawyer either. I can just give you my opinion.
Right. My opinion is educated and experienced,
Right.
and yours is too.
I thank you. And this judicial immunity, it's all got to go. I think family court should just be abolished. That would solve a lot of problems.
I think family court should be abolished, and I'm definitely, that's what my shirt, Invisible Disabilities, Gavel Accountability Forum. I definitely want to see judicial immunity abolished because the Supreme Court says that it flows from common law, but we don't really have a common law court.
No.
And the thing is, most of the principles of common law are out the window, especially in family court,
Mm.
but usually in most courts. And so for a judge to claim an obscure common law principle that really boils down to feudalism and the absolute sovereignty of the king is BS,
Mhm.
and it's unwarranted in our society today. We have people, judges are oftentimes criminals, and
Mhm.
they get to hide behind a black robe and a gavel. So I go against them, and I go against them strong.
Most definitely. They are out of control. I was court watching, and this was just last week, and the opposing attorney was really going after the one parent. And it just reminded me of my opposing attorney. And I just made a face like, and right away I was kicked out. And I had talked to the person, a relative of the person who was going through this afterwards. And they said there were 32 court watchers and they were booting everybody out here and there. People were just getting kicked off.
That so under the Americans with Disabilities Act, 42 U.S. Code 12203 says that it's unlawful, it uses the word that word unlawful to coerce, intimidate, threaten, or interfere with one who is aiding and encouraging another in the exercise and enjoyment of their rights under this chapter, which is the ADA.
Hmm.
And so if you're removed from a court hearing, that's at least interference, if not coercive and intimidating and threatening.
There's no justice.
No, there's not. It's I've seen all kinds of things, and judges uh want to be called Your Honor, and they act like 3-year-old children, and temper tantrums,
Hmm.
uh, bullying. It's a playground fight, and they don't understand uh, when they're stood up to it's a disorient from my perspective. When I go in with the Americans with Disabilities Act, is a very disorienting um, set of circumstances for them. So they really don't know how to act. I mean, I've seen all kinds of knee-jerk reactions, and I mean, I've got videos on my TikTok, and I never thought I'd be doing TikTok,
Hmm.
but it seems like a good forum for me to put out these short frame videos to show exactly what goes on in the courtroom. And I've got plenty of examples there on TikTok. It's certified. My TikTok is at certified underscore ADA underscore advocate. And people can see that there.
I've watched, yeah, I'm impressed.
When you say I'm impressed, I mean, I'm just a guy with an axe to grind.
Oh,
And,
yeah.
and I enjoy grinding that axe. I'm a high school dropout. I'm a college dropout because school did not work for me.
Hmm.
The parameters of the educational construct did not work for me as a young, adolescent and teen, and so in the 12th grade I said, I've had enough of this, and I went and took a GED and went to college. That ended up being more of the same, so I said, I'm out of here.
Hmm. Hmm.
And so I'm fairly educated, and Ron White says, I'm somewhat intelligent, but you can't prove it on paper.
Hmm. Well, you don't have to, it's what you know. It's all in what you know and all your experience that you have dealing with these parents, moms and dads going through this. Have you ever, okay, they have these conferences. Will they let you into a conference? Like for, we'll say, a child support conference. Do they let you in there?
I don't know, but there is a Texas Court Administrators conference that I was thinking about going down to. I may try to go to that to see if they'll let me in. Um, I'm curious if that's going to be something they're going to allow or not. So I don't know.
Yeah, because I tried to take an advocate in with me to this child support conference. They would not let this person in. They said only I had to go in there. And I know why. It's so they can bully you and, make fun of your disabilities.
What was the difference in your credentials and the person you were trying to get in?
Um, well, the credentials of the person that was helping me, she was also a nurse, and she asked to go into this child support conference with me, and they wouldn't let her in.
Just a blanket no, no real investigation.
No, no, no.
Wow.
And the opposing attorney, um, he had mocked my disability, which was my lazy eye, which I can't help because I've had a blow to the head. But he brought that up, and I yelled at him. I said, "How dare you make fun of a disability?" But they don't care.
He didn't recoil at all.
No, no, no. In fact, these two, the ex and the opposing attorney, always look down. They could never look me in the eye. So I said to him, I said, Attorney Taylor, look me in the eye and tell me this is not right. What you guys are doing is not right in the best interests of the kids. And he said, which eye do I look at?
What
And
the
that's when I
fuck?
let him have it. That's when I let him have it. And I let him have it all the way out the door. As they were walking down the hall, people could hear me yell, you know, how dare you talk to me like that? This is my disability. You're making fun of a disability. I reported him to the Supreme Court Disciplinary Board, which is where in Pennsylvania we report. But I'm telling you, they get away with everything.
Let me guess, the disciplinary committee did nothing.
No, it wasn't unethical enough.
Yeah, every client that I take tells me that their court is the most corrupt. So I mean, I get this all the time,
Hmm.
but there are some states that warrant honorable mentions, and Pennsylvania is definitely one of them. California is another.
Oh, right. Right. I think New York is also another bad
Oh
one.
yeah, yeah, yeah. I mean, everywhere I go, it's just it's rampant, and there's a growing outcry against family court,
Hmm.
and so we'll see where that goes. But the thing is, as social media becomes more and more of age, and people start exposing these things, um, there's just all kinds of people that need to be dealt with in
Hmm.
a formerly well in a future non-traditional way, because the way they're dealt with now is judicial immunity and hush hush, you scratch my back, I'll scratch yours, good old boy kind of a thing,
Hmm.
regardless of whether they're men or women. But the legal industry is nothing more than a way to bully and control people who have been uh, had their understanding of how, and the law should be easy. The
Hmm.
law, it should be an easy issue, a moral issue of right and wrong. And instead it's motions and demurs and OFAs that are unwarranted, or orders for protection that are unwarranted. And I'm not saying that sometimes they are warranted. I mean, certainly there are people that need protection.
Hmm.
As a DV survivor, I know this,
Hmm.
but it's used as warfare and as lawfare. And again, I haven't said this in a while, but I want to say this on your uh, podcast. And if you want to edit this part out, you can. But we will have a justice system when corrupt judges and lawyers swing by the neck on Courthouse Square. Not
Everybody,
until,
everybody's been saying that. Um, they've been saying that on Facebook, everywhere.
yeah, it's there's a demand and a cry for retribution that is just it must be heard.
Mhm.
And judges are that hide behind social that just judges that hide behind judicial immunity again are social deviants. And so
Mhm. And I believe they're psychopaths to the point of, well, sociopaths. I can't diagnose anyone as, I'm just saying they're a personality disorder. They relate to these attorneys that are personality disorders that, like you said, bully the other litigant who really needs an ADA advocate as well as an attorney that's really going to fight for them.
right. It's have you ever read the book The Psychopath's Bible by Christopher Hyatt?
Mm-mm.
It's a disturbing book, and he warns you for, several pages in the front of the book, please don't read this book.
Wow.
But it tells people how psychopaths actually use techniques to rule other people. And I was I'm not trying to get into a religious debate, but I was in my youth, I was abused by the religious sect that I was raised in.
Mm.
And so I just kind of went my own way. I'm more of a spiritual guy now. And but the thing is, I consider government to be religion. And I believe that religion is a construct to control people through fear. And that's just my opinion. It doesn't have to be everyone else's here, but government is a religion, and the judge is the god of that religion. And but because there's immunity, there's this sovereign immunity that is unreasonable and untenable.
Most definitely. I think judges should just come out in a suit or something. I don't know why they have to wear their graduation gown into a courtroom. And I think if we took it down to civil court and a parent can have, a jury of 6, I think there would be less conflict. I don't know what you think of that.
Yeah, well, I mean, if we had allowance for jury nullification to be announced, and also juries that were actually peers, you know, so many times. I mean, just for instance, in a criminal case, um, usually the criminal case is styled the people of the state of blank versus so and so, and so one of the voir dire questions that I would ask, me personally, that I would ask a juror is, are you one of the people of the state of blank? And they would say yes. And I would say, well, how can you be an impartial adjudicator of the facts and also be my accuser?
Hmm.
I
People
mean,
also, yeah,
they
right,
they they are.
right. And some people will say, well, they can pay off a jury. I don't know what to think of that.
Well, I'm not sure about that either. But the thing is, you never have a jury of your peers because if the state is the one accusing you, and I mean, I've actually done this in 2007. I had a case of driving with no operator's license, and I asked the judge. I said, "Who is my accuser?" He said, "The state of North Carolina." I said, "Well, factually, what is the state of North Carolina?" He said, "I don't know. Me, you, everybody." And so, I mean, he admitted on the record to being my accuser. And if he's my accuser, how can he be an impartial adjudicator of the facts and law? This case was just in front of a judge, but how can he be an impartial adjudicator if he's also my accuser and admits it on the record?
Yeah, that's a good point. Huh. Well,
So,
I mean, a lot of parents have had to get attorneys that are out of their city in order to get an attorney that does not play in the same sandbox with everybody.
right. And even they have trouble. I've got a case right now that two attorneys wrote and gave declarations that the opposing law firm, the opposing counsel, had harassed them so much that they could not continue the case. And that's unheard of for a lawyer to stand up against another lawyer and say this. And so we're definitely going to go after that. But the thing is, it's when you go into court and you ask for ADA accommodations, you tell them I have a communication disability,
Mhm.
and the stressors of court cause me additional exacerbation of that disability because it causes me to dissociate, to lose concentration, to not be able to think clearly.
Mhm.
I need to have, and so then you say I need to have the ability to ask questions. For me personally, I have social communication disorder, social pragmatic communication disorder, which I think a lot of people have,
Mhm. Mhm.
because it's a context-based disorder. And it means that when someone's saying something to you, what are they actually saying to you? They're using their words to manipulate you. What are they actually trying to do? And a lot of times we don't know. And so for me personally, and for my clients, I ask that they have the accommodation of being able to ask and receive the specific, static, complete, and permanent meanings to words or terms that are used that are unclear or confusing to them. CART is another thing, computer aided real time transcription. They need to have a transcript of what's going on right in front of them on the screen that they can screenshot, record, whatever,
Mm.
so that they don't have to wait 90 days. Sometimes
Oh,
it's 90 days for a transcript, and people walk out of court all the time wondering what the hell just happened.
right.
And they don't know, and so they can't process this. Well, how is it fair for them to have to wait 90 days and pay an exorbitant fee for this to be processed afterwards and know how to combat it? A lot of times it throws off the timeliness factor for response.
I agree. I agree. Some
There's
people go ahead.
there's a lot of accommodations though, and we can get into this a little later, but there's a lot of accommodations that people can ask for in court. It's basically only limited by your imagination. Dr. Huffer taught me this.
Mhm.
And so, you can ask for breaks, you can ask for the ability to record. The ADA actually supports the ability to record Zoom connection to the court instead of going in one-on-one. If you're a DV survivor, SV survivor, you can ask for a barrier to be put between you and your abuser. You can ask for them not to be on camera while you're on camera, et cetera. There's all kinds of accommodations you can ask for.
Mhm. See, a lot of people don't know this. I mean, I knew about the barrier. I've heard of that. And I didn't know you could ask for breaks, you know. But I also heard that these judges can make the decision if the ADA advocate can actually come in with the person who's litigating. That they're allowed to say no.
So they're not allowed to say no under 42 U.S. Code 12203. And they if they're interfering with someone who is aiding and encouraging, we're allowed to aid and encourage. There's no demarcation line on aiding and encouraging. It doesn't say except in court for Title II. Title II of the ADA applies to state and local government in their services, programs, and activities. And arguably, court is one of those services, activities, and programs.
Mhm.
And so, there's no demarcation line for court. And a lot of times, the court administrators will say, "Well, to get ADA accommodations, you have to file a motion," and that too is a breach of the ADA because 28 CFR 35.160B2 says that auxiliary aids and services must be provided in a way to protect the privacy and independence of the individual. And so you can't bring this out in open court, give this information to the opposing party, and not expect them to use it as a strategic information piece that they can use against you. There's just no way. I mean, it's biased. And so judges have this the robe syndrome of I'm God and you have to file a motion before me. That's not true. That's not true, nor is it how it works, nor is it how it's supposed to work, nor is it how it's dictated to work. There's an ADA coordinator that should collaborate with the judge on what accommodations are happening. And actually, the U.S. Department of Justice has actually come out and said that judges, and this is a fact, judges acting in a way that adjudicates between the parties is a judicial act. When
Mhm.
judges are acting in a way that is not an adjudication between the parties, i.e., accommodations for disability, administrative access, that's not a judicial act and does not carry judicial immunity. And so this is something that people need to know
Mhm.
and use.
What about HIPAA? There are cases where the opposing wants the HIPAA notes, say, from the psychologist, from like between the parent and the child. And I think the judge should say no one's getting any records. And because that also is an ADA thing as well, because if that parent, say, has a speaking issue and whatever that is said to the psychologist, for instance, I hope I'm making sense, but I think it should just be no. But these judges hand over people's physical records. What do you think of that?
I agree with you, and it's also used to abuse the people who are affected by those records.
Right.
And as far as HIPAA goes, the HIPAA is applicable to HIPAA covered entities. The court is not one of those entities. So I don't know that there's a HIPAA violation. Again, this is not legal advice, but it's a when people combine the ADA and HIPAA, it kind of gives me a little twitch um, because the HIPAA is not involved in the ADA, but there is a privacy provision in the ADA. And the thing is, when judges allow these medical records to be in open court, that's an abuse of discretion, in my opinion,
Right.
as a layperson. And so they could view these things in camera in their chambers, and they don't do it. They just they allow it to come out like you said. So yeah, it's a huge, it's a power play,
Right.
you know, because in law school they teach you if you have the law, bang on the law. If you have the facts, bang on the facts, and if you don't have either, bang on the individual. You know, and so what they do is they come out and they attack the character of the litigants, and it's just an all-out knockdown, drag-out fight, which is they say they have rules, but they regularly abandon those rules.
Mhm.
And so, and for someone who is unrepresented, they force you and use those rules against you, and they won't as easily use it against each other. You know, it's a club, and it's a big club, and we're not in it.
Yes, I agree with that as well. I believe they're all in collusion. People say judges need to be educated. I think they've had enough education. I don't think they need any more education. What do you think on that?
I think judges need to be educated daily, and I that's part of what I do is educate judges on the ADA. They're usually reluctant.
Mm.
But you know, when they say when you don't have anything else to learn, you're basically dead. You're just, you know, holding a space. And I will continue to learn for the rest of my life. But judges, they have to maintain the appearance of control and act like they know it all, and they don't. They don't. They didn't know. No, I can't tell you because the ADA is obscure.
Mhm.
There's no punitive damages for titles 2 or 3. So lawyers are not incentivized to take on ADA cases. There's compensatory damages that you can pursue, and you can also tie it to other actions like 1983 civil rights claims and get damages that way. But the uh, the ADA in and of itself, unless you're in a state like California that has extra damages tacked onto it, it's not a lucrative field to be in. So lawyers, they get a 5 minute gloss over in law school, and when I come in and know what I know, they're all doing this,
Hmm.
blinking at me like a frog in a hailstorm, and they don't know what to do, and so the only thing they can do is attack. This guy's not a lawyer. He's not entitled to talk. Blah blah blah. And I mean, I've been investigated for unauthorized practice of law just because I'm trying to help someone get administrative access to the courts. So it's uh it's an interesting field.
Hmm. Have you ever had a client that just couldn't handle going into court? They're breaking down crying and they just can't make it through the hearing.
Yes, regularly.
Hmm. And this is what the family court system does to parents. And um, they just should be abolished. I don't know how it would be done because they're making so much money off of it.
Well, I think uh depending on the Supreme Court to overturn this is another snafu
Mm,
because the Supreme Court gave us judicial immunity. They gave us Frazier versus Cupp, which says that cops can intimidate and not intimidate, but use deceptive practices. In other words, they're giving cops carte blanche to lie. And that's one of the disabilities that I have. If I have a police interaction, I can't engage in a consensual conversation with someone who has been legally authorized to lie. And courts are the same way. There's just not a case saying it, except for judicial immunity cases where they say that a judge can maliciously injure you and still claim judicial immunity. And so judges lie all the time,
mhm.
and they're not honorable. Uh,
No.
Judge, so calling them your honor is like, uh, you know,
Mhm,
it's like calling a frog a duck.
mhm. Well, I think people are used to saying Your Honor because everyone's watched Law& and Order so many times. It's like a knee-jerk reaction, Your Honor.
Stop calling judges your honor.
Mhm,
That's a sound clip from this. That's a sound bite. Stop calling them your honor while they sit on a bench 4 foot above you, lie to you, withhold your rights, and
mhm.
abuse you.
Yeah, and destroy your family in the
Yeah,
process.
exactly. Yeah. It's as someone who's lost their family, not by the judicial system, but by the societal framework of the man, alienation.
Mhm,
Um, it's horrific. It's part of our identity is who our family is, and these things are ripped out of our lives, and people are in trauma. They're in response mode, and Judith Herman in her book Trauma and Recovery, and I'm going to do the whole quote on here, and again, you can edit part of this out if you need to. Judith Herman in her book Trauma and Recovery said, if one set out to design a system for provoking intrusive post-traumatic symptoms, one could not do better than a court of law. Women who have encountered this have equated it to being raped a second time. And that's a paraphrase, but that's what she says in her book.
mhm,
And men feel the same way.
mhm.
Men feel just as bent over in that situation as a woman can. And it's not um it's abuse. It's just legal abuse.
And the financial abuse, um, it's just crazy. They want people to pay attorney fees to the opposing who's abusing them. And as an ADA advocate, can you help make that stop, or you just support the litigant?
Um, well, it's an interesting question. I've never been asked that question directly, but I can tell you this. The Here's a good play on that. The opposing counsel in your case has to also uh honor the ADA and give ADA accommodations and make their goods and services under Title III ADA accessible. And so if you invoke the ADA on them and ask them for accommodations, I need you to explain to me what the words and terms mean. I need you to give me extra time to respond. I need you to not avoid the coercion, intimidation, threats, and interference that the ADA prohibits. And they don't do that. I, I personally believe that you have an action against them in federal court for discriminating under the basis of disability. And no one's ever done this. A lot of what I'm doing is breaking ground. And if I actually had a foundation that was funded and I could do lawsuits, I could do some positive changes for case law on this, I believe.
Mhm.
So,
There's got to be changes made. I'm always looking for solutions. People come onto this podcast, they tell their story, and it's like, oh man, they could have used an ADA advocate. And we talk about solutions of what could change, what they should have done differently. As an ADA advocate, is there anything that you can think of that you could have done differently for the litigant?
so the ADA should be invoked early and often. And every case I go into, I try to make it as explicit as possible when I write my letter to the court. I give them not case sites, but law sites from the Title II, and I let them know what the requirements are. And invariably, I mean, it's the rule. They're going to break those rules. They're going to break those provisions of the ADA. And so the more you document that, the more recourse you have. And courts have deniability on disability until you invoke it. And so I encourage people to invoke it early and often. And when you go into court, I'm going to go ahead and give you the script on this podcast that we're doing. When people go into court, I give them a script, and they have not been their ADA accommodations have not been met or addressed, or maybe they're denied. There's a certain way they have to be denied under Title II, and they usually never do this. And if they don't have those accommodations when they go into court, you can shut the court down by just saying, I do not have ADA accommodations. I do not have ADA access to this court, and I've asked for them, and the accommodations have not been granted, or they're ineffective for me. And then the next thing that the court's going to do is ask you on the open record in court, well, what's your disability, or what accommodations do you need? And per 28 CFR 35.160B2, you're required to give me privacy concerning this. Please do not ask me that in open court again. This is a private matter.
Mhm.
And that loop of I do not have ADA access and you can't ask me about it in open court, that shuts a court down.
That's fascinating. That's fascinating. So that would shut down a hearing.
Yes.
You know,
And you're going to get a lot of blowback from the opposing counsel. Your Honor, they're this, that, and the other. They're trying to prolong and all that's discriminatory. You've just invoked a disability, and now they're coming against you in an intimidating, coercive way to say that you're not for real. So now it's discrimination. And there's a provision in Title II that says that the court cannot perpetuate discrimination. So if the opposing counsel comes up and says something, and then the court says, yeah, it seems like they're just, yeah. I mean, there's all kinds of perpetuation of discrimination that goes on in court cases when the ADA is invoked. And so I'm there to document it and record it.
now, do you make sure the litigant has their physician verification forms, everything all ready to go on time? Um, Only because with these we call them PVFs, but the judges don't care about that either. When you're trying to explain, oh, I can't work due to compressed discs in my back, whatever. The physician is backing this up, and the judges don't care.
Now, for your case, it may be different,
Mhm.
but for the ADA, there is no requirement for you to have a doctor's note to invoke the ADA or claim a disability. A disability can be anything, and actually, there's also a regarded as prong of the definition of disability. So when a court says, "I need just you, just this one side, to go get a psych eval," and they're not telling the other side to do it, in my mind, and according to ADA principles, they're treating you differently on the basis of disability than they are the other side. So that's a discrimination. And
Mm.
so there's no requirement though for a doctor's note, a doctor's letter, a form, none of that. And a lot of times they offer an ADA accommodation request form that says we need you to get your doctor to sign this. Not so. And so there's a case called Sugg versus City of Sunrise, SUGG versus City of Sunrise. And the ruling in that case, which is unpublished, ironically, because they didn't want people seeing this, I'm guessing.
Mm.
But it said it was a Title One case, an employer-employee case, ADA. And the employer said, well, Mr. Sugg's testimony was self-serving about his disability,
Mhm.
which is, an intimidation tactic. The court said, well, even though it may have been self-serving, you should have given it consideration. That's in the most stringent application of the ADA under Title One. So if you're going into court under Title Two, and Title One has the ability for an employer to ask for medical records,
Mhm.
but Title Two and Title Three do not. So you don't have to take a note into a store or a court or a tax office or, there's also a case, Lou versus Lopinto, LOU v Lopinto, and this case, the United States Department of Justice came out and did a statement of interest in that case, and they clearly lay out how that all your interactions with law enforcement are supposed to be ADA compliant. So when you're involved in dealing with a cop, I invoke the ADA right off the bat and ask for accommodations. I've got a card that I carry with me,
Mhm.
and so I don't have to think in the moment. I just give them the card, and so it's a excuse me there for a moment. Um, it's it's a misunderstanding that one has to have a doctor's note to get ADA accommodations. That is not so. It's not required by the ADA, and courts are abusing their power when they demand or ask for this.
Right. I went in with a litigant, um, oh, I don't know, a year and a half ago, and she was trying to get her ADA in there to be on the screen so the judge could see her. And her opposing attorney was like, "You don't have a disability." The way he talked to her, and then um, I did step in and I said, "This is what can happen if you don't allow this. This and this and this can happen." And he said, "Who are you?" And I said, "I'm just a podcaster that runs Slam the Gavel." And then he grabbed the opposing attorney and they went into the judge's chambers and wasted time in there. And then they came out and said that they would revisit this at a later time when they can have all this organized. It was something like that.
Yeah, it's a lot of I don't get the who are you so much because I promote by certification up front, but I do get the you're not an attorney, you can't speak to this. Well, yes, if it concerns administrative access, I can speak to this.
Right.
And right now, and see, here's the thing: you can get into a case, get in the middle of a case, be up on the stand, and if an attorney says something discriminatory and it causes you to dissociate, immediately you're removed from the legal side of the frame and placed back in the administrative without access. So administrative access denial can occur at any time. And that's something that you need constant encouragement and aid for. And that's why the ADA put in there that anyone who is aiding and encouraging, who are you? Well, I'm here under a protected federal capacity of 42 U.S. Code 12203. I'm aiding and encouraging Mr. or Ms. So-and-so in the exercise and enjoyment of their rights under the ADA.
Mhm,
And if you interfere with that, federal law says it's unlawful.
mhm.
So govern yourself accordingly, Judge.
Right. I mean, I was with that litigant because we were waiting for them to set things up to have the ADA on the screen. And so I was just helping that ADA out by being there and explaining that this person needs the ADA advocate and we need all these things in place, even though they were given a letter a week prior to all of this, explaining all of this. So these courts aren't on the ball at all.
It's amazing. It's amazing how quickly a judge can go from ignorant to all knowing.
Yes.
I mean that's just a ping pong match. I don't know what you're talking about.
Mhm.
I don't understand what you're saying. I mean, I get these comments all the time, and then at the same time, well, you can't do that. From ignorant judges move. It's like it's disorienting because they move from ignorant to all knowing so quickly.
Mhm. Yeah, I mean, I'm just so glad I had you come on the podcast, because I'd like to have you come back on again. And, how can people reach you if they have any questions?
So my website is ADArightsTrust.com. ADArightsTrust.com. And I am on TikTok at certified_ADA_advocate.
Yes, and people can leave messages there, and I will put all of that in the podcast notes as well. Is there anything else you'd like to add?
Judicial immunity is social deviancy.
It definitely is. And, I'd like to have you back on again, like I said, but hey, don't jump off, okay? Slam the gavel.
Okie doke.
Slam the Gavel is a podcast to help the public understand what really goes on in these courtrooms. I'm your host, Maryann Petri, and you can find me on Spotify, YouTube, Apple iTunes, iHeartRadio, Google, other platforms I don't know about. Again, feel free to buy me a coffee in the podcast notes to help keep this podcast going. Thank you, everyone, and everybody have a great day. And thank you, Jay Shore, ADA advocate, for explaining what is going on and what needs to be explained.
Thank you for having me. I look forward to this again.
You'll be back.